I'm overjoyed to have you all here tonight. I actually am. I was thinking about this last night and I started tearing up because who would have thought that all of these wonderful people would get together to talk about how to prepare for dying? So a few years ago, I had this idea. I thought, you know, I heard about something called the Death Cafe, and this feels very close to that. But I just liked the concept of people coming together to talk about things that are kind of difficult, but to face them head on. And I generally like to do that. I mean, some might say I'm overly direct sometimes. Some of you might say that about me when I've talked to you about your estate plans. But I really am overjoyed that we are here tonight, that you all made time for it, that you crossed the bridge. If you did, I promise we will get some seminars or events on the other side of the bridge. I have some great ideas. But I really am grateful for your time. But if I don't know you, my name is Annie Arbenz. I founded the Narrows Law Group back in 2014. I was about as pregnant as Lindsay is today. And it was at the time challenging, but I knew when I was starting the firm that I could do it better than I thought estate planning was going, and how I was trained and mentored by wonderful attorneys. But what I knew was true is that it was a much more, well, let me back up. Estate planning to me is not about documents. I think if you know me, you know that's true. If you know any of us, you know that's true. It is about the relationships that you have in your life. It's about defining what your life should be and how you want it to be. Thinking about your legacy. It's so much more than documents that we put your names into. And I'm so proud of what we've been able to do here and how we've been able to help our clients over the last, my son is almost 12, so 12 years. So in the early days, it was just me, and I had a part-time paralegal, and I was just waiting for appointments to come onto my calendar. Things have changed a bit. Now there are 4 of us estate planning attorneys here. We have, let me introduce them. This is Hannah Rowland. Hello. Please clap if you like her. Caroline Brink. And Lindsay Appleton. Like I say, Lindsay, well, can I share?
Yeah.
Okay, yeah. Lindsay's having a baby next week. But don't worry, she has a court hearing on Wednesday, so she scheduled it for later that evening.
I'll go to court first.
She's amazing. Anyway, this is an amazing group of estate planning attorneys. I've never met more personable attorneys in my life, and I'm just so grateful that they're here with us. You guys met Kristen. We also have Logan and Jennifer and Taylor and Teresa. Big round of applause. Woo! Some of our staff are in Hawaii or doing life things, so they couldn't be here tonight, but we would not be who we are without them. And I'm so, again, grateful that they're here on a Thursday night. That's pretty nice. So it's a special team. We get to do a lot of important things, and we love doing it together. So without further ado, let's get to the topic. Oh, no, I'm sorry. I don't have a script, which I probably should have. And I know Hannah's my sister, and she's probably like, Annie, wrap it up. But
you're doing great.
Thanks, I'm doing great. The Bridge Club is, and you're all members of the Bridge Club, by the way. We opened up this is our first one, as Kristen said. The plan is to have more of them, maybe a couple of years to start. We don't know. So we thought, well, we'll keep it kind of small and see if anyone comes. And we said, at least our parents will come. And we do have some parents in attendance tonight. So thanks, parents. And thanks for, everything. But we didn't, yes, thanks to the parents. We didn't, the Bridge Club is a new program that we started in 2024, and it is that 5-year, let's call it a subscription, but it's more like a membership, and that's what I've considered it. And it is kind of the end of a long time dream I've had to, again, create space for talking about death and difficult things, but really practically speaking, to help connect all of you individually to our team here at the firm, so that we understand what's going on in your lives and we can help you over time and make sure that what you've put in place with us and your estate plan continues to work for you. And that is actually the driving force behind everything I do is to make sure that these things continue to work. So the goal in opening and creating this firm and creating this team has been to help clients over time understand that estate planning is not just transactional, right? It is not about signing documents, filling in blanks, and we'll see you when someone dies. It is absolutely about the relationships and understanding your family's dynamic and how your family should affect and should create the plan that we put in place for you. So that has been our focus, and I don't know that many firms are doing that. I think it might start now that AI is such a big deal, but it's very important to us and central to what we do, which is why we started the Bridge Club and why you all are in it. You get it when you when you establish your living trust with us, but you can also add on with wills if you go with wills instead. So we'll talk about some of that stuff, but that is really the focus tonight too, is how to help you all understand some of the biggest issues that come up after someone has died and what you can do now to help prevent those issues from coming up with your family members. So I think what we wanted to do is start off with a little story. You decide if this is a fact pattern that actually happened in our practice or if it's something that we made up. Bill dies. That happens all the time. Sorry, Bill. Yeah. Not this Bill dies. Bill has, okay, so before I start this, I want to take you back to our law school days. This is very much a law school fact pattern, so I think you might identify some issues with us as we go through it. Not this Bill has 3 children. Their names are Scarlett, Richard, and George. Scarlett and Richard are 27-year-old twins from his first marriage, but George is only 6 and has a different mom than Scarlett and Richard. Bill wasn't married at death, but had a newer girlfriend, Andy, who was living with him when he died. Bill's dog, Venkman, is living at the house with Andy. Bill did some estate planning when his twins were 19 and before George was born. Bill's daughter, Scarlett, comes in for a consultation with our firm after Bill dies. Scarlett has some paperwork that she found in Bill's closet, which includes copies of his living trust and a will. She doesn't know where the originals are located, but they might be in a safe deposit box somewhere. Scarlett's the appointed trustee in Bill's living trust, and Richard is the executor of Bill's will. Yes, there are 2 different people in those roles. The documents distribute the estate to Scarlett and Richard in equal shares, but guess who's missing? George. The 6-year-old. Scarlett also found a small pocketbook with some handwritten passwords in it, most of which are crossed out or unreadable. Bill had a P.O. box that he used for mail, but Scarlett can't find the key. We asked Scarlett for information about Bill's assets. She tells us Bill was very private and she doesn't know much except he had a Columbia Bank checking account, or checkbook, his house in Gig Harbor, and a vacation house in California. She looked up the records because Scarlett's a good daughter and thinks the Gig Harbor house is in the living trust, but that the California house definitely is not in the living trust. She thinks he might have had some cryptocurrency and some Kurgans hiding somewhere. She also thinks that she may be on one of the accounts with Bill because he mentioned at some point that he was going to do that just in case. My staff's freaking out because this is a horrible fact pattern. Based on the values of the real estate she knows about, Scarlett believes Bill's estate is probably close to $4 million. Y'all know what that means, right?
Oh yeah.
Oh yeah, okay. Scarlett is a little concerned because she knows Bill once had a pretty bad gambling addiction, so she's not sure if he owes people money. Then Scarlett begins to tell us about her siblings. Her twin Richard was a baseball star in high school, got injured, and developed an oxycodone addiction. He didn't end up going to college, and he has struggled ever since. In fact, Bill and Scarlett haven't talked to Richard in 5 years, and she doesn't know where he lives. He might be on the streets. Her younger half-brother George is in kindergarten, and his mom, George's mom, has turned George against Scarlett and Richard, mostly because of Richard's drug addiction, but also how Bill treated her when she had George. Also, it is highly likely that George's mom, Bill's ex-girlfriend, is the beneficiary in a life insurance policy. Scarlett is very concerned about how to deal with her brothers and George's mom. Scarlett does remember her dad saying that he wanted to be cremated and scattered in the Puget Sound, but there isn't anything signed to that effect. Oh, and towards the end of the meeting, Scarlett asks, oh, by the way, Richard was convicted of embezzlement 3 years ago. Is that going to be a problem? So, Lindsay, would you take this case?
I would take it if I had a lot of free time and I really needed to get a chunk of that $4 million. But I'll tell you, so just to kick off talking about probates and living trust administration, if Scarlett were in front of me, and I know going in that my fee agreement for a probate is $3,500 for your initial retainer. After listening to Scarlett, her retainer, and I wish I was kidding, would probably be $10,000 because of all of the work that would have to happen. Because we would be doing probate and trust administration, and I'd be having to find a California attorney to do a probate in California, it sounds like, which I know if you're one of my clients, I have told you that if you even think about buying property in California, you must have a living trust because probate in California is awful and expensive. They actually charge you a portion of the value of your estate. So let's hope that his home there isn't worth much. So no, maybe I'd take it. Depends how desperate I am. But right now, typically no, I'd probably turn it down because it'd be too much. And unfortunately, I think there would be a lot of law firms that would say, no, I'm not going to take this, because we hear that a lot from clients saying, I've been turned down. And I'm like, I know why. With this, so we're here to talk about the logistics. What are the first things that we do? And what did Bill do wrong? And what did Scarlett do right? Oh yeah, that is probably one of the few times in my life I've been asked to be louder. So I'm so kind of, does anyone know like what Scarlett did right? Not Bill, because not much. That's the answer I was looking for. Yes, Scarlett called me, but also Scarlett was industrious enough to go look for documents before she came to an attorney. Okay, what Bill didn't do, rest in peace, Bill, but what he didn't do correctly was he didn't put all of his documents in the right place. He didn't tell her where anything was located, but she found documents. She came to me and she started to tell me everything, which doesn't always happen. So this is also the tip. Tell your attorney everything you know right off the bat. We really, really hate getting 3 weeks or 2 months or 3 months into a case and finding out, oh, by the way, I have this other sibling, which has happened. Yes. Jen is aware. So she's come to us. We're telling her you now need to do probate and you need to do trust administration. We ask her, one of the first things we ask someone, and a lot of people don't have this, do you have the death certificate? And a lot of people try to come to us without a death certificate. And I say, I actually need proof that they're gone. And the court's going to need a death certificate. So let's get that going. So to open probate here in Washington State, and I have to say, probate in Washington State, not as bad as California, that's for sure. But probate in Washington State is going to be changing very soon. I think it's June 11th that we actually have new laws kicking into place. While I'm on maternity leave. But we're opening probate. When we open probate, we have to use the will. In the fact pattern, the will says Richard is the executor. Richard, unfortunately, also has a felony, embezzlement. He is going to be disqualified. So we're really hoping that in that will, there's an alternate. If not, we're gonna have to do a lot of paperwork with the court. This is another reason why this probate costs so much. So we can't find Richard to turn it down. Right. So we're trying to locate Richard. We're explaining to the court he's actually not able to do it, and here's why it should be. Is it Scarlett? I don't know, because guess what? We have to get permission from George's mom, who doesn't like Scarlett, I don't believe. So there's a lot of footwork there. So those are the probate issues. But once we get probate open, and I'm going to work miracles because we're assuming I take this case on, George's mom is going to accept and say, go ahead, Scarlett, do it, because I don't want to do it. Scarlett is appointed. Probate is open. We also have to deal with trust administration. Okay, so what trust administration looks like, and I think a lot of you guys know from when you talk to us, but we're going to refresh because that's what we're here for, is your fiduciary, whoever your successor trustee is, in this case, right, it's Scarlett, she's going to hand me the death certificate, and I'm going to draft up a new certificate of trust for her. And I will say, now you are trustee. You get to go marshal all of the assets that are in the name of the trust, and you get to put it all into a new trust account, okay? It's easier said than done. And I tell her, in 3 months, you're going to give me an inventory. You're probably going to give me an update sooner than that of what's in the trust and what's not in the trust. We're going to parse it out. We're going to hope that Bill put most of his assets into the trust, right? Let's see. I want to make sure I'm hitting on everything because I think I'm hitting maybe on too much of what I'm supposed to do here.
No, I think it's good to just point out that there's no court involvement.
No.
If Bill had everything in his living trust, there would be no probate.
Yeah.
In California or in Washington. And it's not, we've had this discussion with every one of you. It's not worth doing everything to avoid probate, but depending on your assets, it might be. Bill should have done everything he could to avoid probate for Scarlett's benefit.
And he certainly should have had a will that named the same executor as the same successor trustee. And I do know I've had clients, and I don't remember if they're my clients who are here, who've asked me, can I have a different executor than a successor trustee? And while I give you guys a lot of decision making in your documents, that's the one time I say, please no. We're not doing that. So that's really how we get going with those two. And probate, this is really what I tell people when it comes to the start of administering any estate, right? Whether it's a trust or probate. It looks different with probate. There's a lot of work to get it open with the court, to get what are called letters testamentary, which is that document that gives your executor the power to go marshal your assets. And it can be very costly. I typically tell people in a smooth case, I'm going to actually spend probably over $2,000 just getting a easy run-of-the-mill probate opened. To get this one opened, I'm probably spending over $5,000, maybe $6,000 just to get it open because of all the paperwork, all of the communicating, everything that we have to do. Once probate is open with the court, administration looks really the same when it comes to trusts versus probate. All of the tasks are the same, right? We're marshaling the assets. We're dealing with creditors, which Bill may have creditors thanks to his gambling. What do we do when you have creditors when you pass away? If we have bills and we have, credit cards coming in, things like that, we're going to send them direct notice and say, so-and-so has died, and we have published notice in a particular publication of this death. That's basically a hear ye, so-and-so has died, come and bring your claims. That's really what I say in my meetings. I do
That's really cute.
And so we do that in probate. We publish notice to creditors. We send notice to known creditors. And we hope that maybe these loan sharks are looking in our publication. Actually, we hope we're not looking in the publication so that when your 4-month creditor claim period is over, let's say we have someone who says, so-and-so had a debt with me, and it was a credit card, and we sent you direct notice, you're cut out. You did not put a claim forward in a timely manner. Please do not take this as legal advice to run up your credit card and hope that they don't make a claim, because some people have asked me that.
My husband always says, we get a month free.
Yeah.
Like, no, you have to pay for that eventually, even if you're dead. Right?
Your estate will likely pay for it. Yeah.
That's right.
So in this situation with Bill, I would definitely be telling Scarlett, we are most certainly publishing notice, but you do need to know if you think there are people he owes a debt to, we got to find them so that I can give them direct notice so that we can apply that 4-month period to them, right? So those are some of the creditor issues. But it also means one of her tasks is you have to try to go through his mail, which means you've got to try to get a key to that P.O. box,
right?
Okay? Because he didn't leave it for her, so that we can send direct notice to all of the creditors that we can. I find really joy in cutting off creditors. It's really unfortunate.
It's great. It's like a mini bankruptcy proceeding, right? You say, hear ye, you have 4 months to file a claim against this estate. If you don't, you're out. We've seen a lot of bills not get paid that way. It's really fun for us.
And you can call and negotiate.
Yeah.
You also can call and negotiate creditors, which is really fun.
Yes.
You say, hey, I'll give you half tomorrow.
Yeah.
That kind of stuff.
And if, when you go through your estate planning documents, again, I know that there's the portion where it says debts, and it says, my executor or trustee shall not pay debts solely due to my death. And that is because you can negotiate them down. And not a lot of people know that. It is something I tell executors all the time. Go ahead and negotiate these down. Mom ran up the credit card for QVC for $17,000. Let's get that down to $10,000. Happens all the time. That is also, all my examples are real life examples. It's very much a QVC credit card. So, one of the other things that is part of administration, and actually it actually usually comes up first, is I have unfortunately had people come to me crying on the phone about what do I do with my mom. And I say, well, what do you mean? We're not going to start trust administration or probate yet because you don't have the death certificate. And they say, no, what do I do with mom? Because I don't know if she wanted to be buried or cremated or composted, which is an option here in Washington. And when this happened to me, the first time it happened to me, and I had a daughter call me crying, and my client had signed her estate planning documents 3 weeks before. And I didn't press her to make a decision because back then it wasn't that important to me, I hate to say. And then I heard her daughter hysterical. And now I tell my clients, and I actually think they could probably attest to this, I go, don't make me listen to that phone call ever again or deal with someone crying like that again. It is really important that you at least indicate what you want done with your remains. And even better, what you can do is make prepaid plans, right? If you want to be cremated, calling a place like the Neptune Society and making a plan. If you want to be composted, we have various organizations in Washington where you can do prepaid plans, which is locking in the price too, which is a consideration for a lot of people, right? But it makes it so much easier for your loved ones. And that's why we do what we do and why you're doing your estate plan, because it gives you peace of mind because you know everything's going to be easier for your loved ones at the end, which also means taking care of your remains. I have had clients that say the best thing my parent did for me was get a prepaid plan because I don't want to have to deal with that phone call of what to do.
Can I ask, just sorry to interrupt, Lindsay, how many of you have prepaid for your memorial or burial or whatever you're doing?
Okay.
Yeah.
Well, I'm really glad I'm talking about this then, because it's, again,
it's not fun to do, and you get an urn in the mail, apparently. If you're going to get cremated, they'll send it to you. So
Yes.
that's something.
My great aunt picked out her urn and it was sitting there and we knew and it was beautiful. And she said, that's where I'm going, honey. I said, I know that is where you're going. So that is actually something that I really press upon a lot. And back when I litigated a lot more often, I actually had to go to court over ashes twice because I had kids who couldn't agree where their parents were going. And to be honest, one kid who was using it as a bargaining chip to get more out of the estate in terms of jewelry, etc. Mm-hmm. So our disposition documents, as you guys probably remember, you all have them, says what you want to happen with your remains, says who is in charge and has the right to manage them. And that is very important because it keeps me out of court or fighting with another attorney talking about hand over those remains, or I'm going to have to air all of your dirty laundry in court. So that's something I like to press on people. The cost of doing this, since, sorry, I didn't plan on spending this much time talking about it, but we have a lot of people who haven't done it, and so I'm trying to really convince you guys to do it. The cost of burial, right, is usually around $10,000 to $15,000, depending on what you choose. Composting is around $7,000 when you prepay. Cremation around $4,000. So,
It was maybe 5 years ago. It was 4,000.
$4,000 for the cremation
No,
or composting?
composting.
Composting.
Oh, yeah, it's more now.
It's
You got a deal because it's more, it's like 7,000
Yeah.
now, I think. Yeah.
Little known
Inflation.
fact, we all took a field trip to composting center. And it's,
People's Memorial Society, you join,
Yeah.
$50 now, it used to be $5, and then they have a set price for everything, a lot less than all that you're talking about.
oh, great.
Like
People's Memorial.
$700 for cremation, and
Oh, yeah.
you can do your burial any way you want, and it's nothing. I mean, the prices
Okay.
are half. You get list prices, not marked up.
Not the marked up prices. Okay, People's
bargain.
Memorial, everyone. I'm not selling them, but they're apparently
Sponsor us.
the way to go.
It's very quick and easy. When someone dies, you just call their number.
Yes.
They send the right person from your area. It's all handled. You don't have to do anything, and they can do the death certificate at the same time if you wish.
Oh my gosh. Linda, yes, thank you so much. Because
Easy.
that is what I want to hear. That is what I've heard from people who say, when my mom had this plan, it made everything easy for me because I called a number, gave them like a account number, and boom. They came, they took care of everything. And that's such a relief because this is all happening really immediately after, the passing of your loved one. And so to take that burden off of you, I think is huge. So that is my much longer spiel. Oh yeah, but we have
One quick other thing. You can donate your body to science, like to the University of Washington. Doesn't cost you any money, and they are desperate for bodies. So 5 of my family members have done it. It's great.
Desperate
Call 'em up,
for
take your
bodies.
body, they take it back.
So the highlight that Linda's just saying that the hospitals are desperate for bodies. So if you want to donate your body to science, it is actually quite wonderful. You do have to be very specific in your planning
It's-
to
you
communicate.
have to set it up. You have to sign
Yep.
the papers
Yes.
yourself.
Yep.
I was gonna say, I know you have to kind of
Gotta
pre-plan
be
that too. There's a paper to sign
Yeah.
for you to give permission for that to happen. And then I know that you were raising your hand.
Thank you for repeating the question back.
Oh.
We can't hear.
You got it.
Oh, okay. Sorry, I will be louder too.
So I
Motion
think
passes.
it's fair to okay. So Lindsay says maybe not take this case, but I think it's important to understand that regardless, I mean, if it's a probate or a living trust, there's a lot of the same things you have to do. The central issue and the difference between them is it's an access issue, and whether the trustee typically has access to your assets faster, whereas an executor of a will has to go through probate first to get appointed. I say it's kind of like get the blessing to go on and be the executor of your estate. So there's a lot involved with probate. A lot of that's also involved with the trust, but the access issue is really the difference. And I think generally, would you guys say it takes? Well, Jen just said it to me the other day. She said, I really haven't talked to the client on this trust administration in a couple months because they're just handling everything. Whereas with the probate, there's a lot of structure. So one's not necessarily worse or better than the other. It's just kind of how your estate is set up to identify the best way to handle your estate. Okay, Caroline, what would you, let me ask you the same question that I asked Lindsay. Would you take this case? And why not?
I would not. I am someone who likes things to be really organized, and this sounds really messy.
That's a good idea.
I know that all of you are organized because you're spending your Thursday with us to talk about what you can do to make this easier on your people, because you all have great documents in place, but it only... Keep it up here. Am I not? There you go. There you go. There you go. I'm not used to speaking to a microphone. If you have great documents in place, but nobody can find them or nobody knows where any of your assets are, it's kind of pointless. And you've spent all of this time and energy to put money and effort into getting the documents together. So we want those to really pay off in the end. And one thing that Bill was not is organized. He didn't tell anybody where his original documents were. I have clients ask me that every single day. Where should I keep my documents? Where should I not keep my documents? And my answer to that is a safe place, ideally at your house, where most importantly, your trustee knows where they are and can get to them. You don't have to have a huge safe in your garage or anything like that. It can just be something small that you can get on Amazon. I think they have them at Costco to just put them in a safe spot. Most importantly, though, that your executor can find them or trustee. I do not like a safety deposit box at a bank. They're hard to get into, which is the whole point. But if we can't get into it after you've died without a court order, and there's a document that gives someone the authority to get into it, but it's inside that box, we have all kinds of problems, so I don't like them. I could go on and on about that. Some people are really tied to their safety deposit box.
Add your trustee to your box.
Or
if you
add your trustee
have to have
to the
one.
box, which is tricky if they don't live here, but anywho.
Yeah, that's a takeaway. If you have a safe deposit box and you are committed to that safe deposit box, make sure your person has a key as well as being on the box. They have to be on the signature card. And ladies, don't they have to go to the bank in person to sign the signature card?
They do.
So if those things are true, you can keep your safe deposit box.
But only
otherwise,
then.
get rid of it.
Yes. And if you put it in a safe, someone needs the combination.
Yeah.
Yes.
I didn't quite understand something. I thought I knew, but I didn't.
Yeah.
You said something about the executor and the trustee should not be the same.
Oh,
I
They
didn't quite
should be the same. They should, yes.
The question was whether the executor or trustee should or should not be the same person. The short answer is they should.
Okay.
Yes.
And we will come back to that
Yes.
issue in a second. It's a great point,
Yeah,
Harry.
it's the same role. So I have had people say, well, I want one kid to be the trustee and one kid will be the executor. And I say, well, why would we do that? It is the same role. It's just whether the will is going through probate, trust is trust administration.
When
So,
I heard that, I almost cried.
oh, okay. Okay, well, I'm glad that we were, no, same person.
All right. So original documents, someone needs to know where they are and how to get to them. Another thing that Bill did not do is tell anybody what any of his passwords were to any of his online accounts or his phone or anything like that. And we are in an age where everything is online. And if no one can log into your bank account or anything like that after you've died, we've got a big mess. That goes for social media too. I think there's all kinds of things you can do with your social media after you've died. One option would be to have a password book that you keep somewhere. But what I like and what we like is kind of an online password management system. Where you've got one master password that unlocks all of your other passwords. Now you cannot forget the master password. That is really important. And I will say that a lot of times that master password has all kinds of rules. It's about 20 digits long because it's very secure, but you can't lose that one. Got a question in the back.
Fingerprints, facial features, how do you get by that?
You don't.
You need to, you contact the phone company, and then also a passcode will also unlock your phone too if it's not recognizing your face or something like that. So good question though, because a lot of it is that. He also may or may not have crypto. If you don't have the password to crypto, that's also gone, right? If you can't log into that, so that's pretty important.
How many of you have? Well, you don't have. How many of you have crypto? Yeah, crypto seems to be a big deal these days, but it's okay. Great. If you do have crypto, maybe a couple of quick points on that. If you're not sharing with us, then that's fine. If you don't, that makes things easier, honestly. But the physical passcodes, things like that.
Yeah, there's all kinds of different passcodes for crypto, whether it's a cold wallet and a hard wallet. But if you lose that, either a physical key or the digital key, then it's gone. You can't access it. There's really nothing that you can do. I haven't heard of any workarounds for that kind of thing.
And that's like the point of the asset.
Right.
Yeah.
That is the point of the asset. The other thing is cryptocurrency is actually considered personal property. It is because of that, because you can touch it and feel it in the form of access, right? It's not, we are still dealing with crypto as a country and how to regulate it, but right now it is personal property. So technically, it could go on the personal property list, right? So, okay, no one here has crypto, obviously, but if you do, be very careful with how you communicate the access to others.
Sorry, personal property as opposed to what?
It's crypto is personal property as opposed to a financial asset.
Tangible personal
Or,
property.
Yeah, excuse me. It's like tangible. They consider it like a car. It's treated that way under law because we are still figuring it out,
It might change though.
and it might change. Yeah.
So if you have your attorney hire a professional executor,
Yes.
how do you get the information to where all your documents are stored at to them?
Hypothetically, if you have a professional actually, that's a great. I think Caroline's going to touch on that. The question is, how do you communicate to a professional executor all of this? Like, how will they know that you died, right? Yeah, Caroline's going to cover that in just a minute. Yep.
So, a couple of different things. A lot of people will have another trusted person that they tell us And I mean, I've told clients that they can give me that information if they want to, so that we have it, so that somebody can access it. But I think that it's important that you at least have somebody, because you may not know who that professional is, right? Because that's who we're going to appoint after you passed away. And so that is a tricky thing that I have people ask me all the time is, how is someone gonna know that I've died? Somebody else needs to know, right? Yes.
Sorry, I had this conversation with a couple, maybe not long ago. Yeah. Oh, volume. Okay, louder. Man, I'm really going to tell my mom that you're telling me to be louder. She's not going to believe it. There are people who have in their estate plan, it's either written, a professional appointed by the Narrows Law Group will serve as my executor or trustee. And that means that we will be contacted, and I have to tell the client, make sure you know someone in your life, your neighbor, a loved one, needs to be able to tell us so that we can appoint someone, right? But some people have a professional appointed by, I'm just going to say, like a Pacific Guardianship Services. They're local in Tacoma. And if you have someone like that, or a professional firm like that, you actually can, my advice there is, whenever you update your estate plan, you give them a copy of your estate plan. And still, you have to have a loved one, right? Notify them when something has happened to you. Because even if they're your financial power of attorney as well as your healthcare power of attorney, they're not going to know when something happened to you. So I tell them, maybe it's a neighbor, a coworker, a trusted friend knows, here's who you contact if something has happened to me. But you can very much, if you know the professional firm that is going to act as your trustee or your executor, you need to be updating them with your estate plan. And some of them actually have programs where you can pay a yearly fee to meet with them yearly and update them on, this is what my life looks like, this is what my health diagnoses are, and here are the important people in my life that you can call. So kind of depends what you go with, but especially if it is a professional appointed by us, please let someone in your life know. So, and I always say, like a neighbor who would know, if I saw an ambulance go there and I think something might happen, that they know to call us so that we can get on it.
One of the biggest issues that Bill has to do with all of his assets that nobody knows where any of them are, okay? He has not kept up with an asset list over time. Scarlett is going on a wild goose chase looking for assets, trying to get into the mailbox, but she can't because she doesn't have the key. She can't log into any of his online accounts or anything like that. So she is really stuck. And so we say to kind of keep up with your assets over the years. I say annually, to just make sure that everything is where you think it is. And that kind of ties into, I mean, if you have a living trust, you need to be doing that anyways to make sure that all of your assets are properly titled, have the right beneficiary designations, because if you have property anywhere, but especially in California, that's not in your living trust, that's got to go through probate, and you've done all of this work to avoid it. And so that's another reason why Bridge Club is part of a living trust, right? That's part of our job, is to make sure that you keep up with that over time and kind of condition you to know, hey, if I get a new asset, I need to tell Caroline about it, or else she's going to check in on me in a year and get on to me about it. And so if you have not signed your living trust recently, we have this new living trust funding packet that has every single kind of asset that you could. Ooh, right? Very exciting.
Love it.
We worked really hard on this, and it has a page for every kind of asset that you can think of: life insurance, retirement accounts, investment, crypto. Okay.
Oh yeah.
And you can go through it, and over time, as you get new assets, look at this, kind of see a little bit about what you need to do with it and why, just so you can understand your living trust a little bit better. So we have several of these printed out that you can take home with you today to just look to over time, because it is kind of a confusing thing, and different assets have different things that need to be done. You don't tie certain accounts to trusts, you have beneficiary designations, that kind of thing, so you want to be really intentional about that over time.
The same is true, Caroline, for if you have will. If you have a will, you just need to make sure the titling on your assets continues to be accurate and as intended, and also the beneficiary designations work together. It all needs to work as part of a puzzle.
Yes, and speaking of that, he has an ex-girlfriend as a beneficiary on his life insurance policy, which is probably not the intention and is going to override what his documents say. So if you have beneficiary designations on an account that are outdated and inconsistent with your plan, you really need to double check them. It's always worth double checking. If you know for fact that what your beneficiary designations are, I still want you to check them and make sure that you have contingent beneficiaries listed as well. And if they're inconsistent with what your plan says, that needs to be on purpose. If you want somebody to get an account, that's okay, but it needs to be done intentionally and thoughtfully, and you need to know what it is and update them as your life changes, okay? He also has a joint owner on his bank account in his daughter. That may not be intentional. It may be for convenience purposes, but that creates ownership in her so that she does not have to share with her brother, who's also a beneficiary, unless she wants to, but that opens a whole other can of worms. So you just want to check your account titling and beneficiary designations to make sure that they're consistent with what you're putting in place, or if they're not, that is on purpose. And I think that is what I have.
Perfect.
Joint ownership, may I make a comment?
Yes.
Joint ownership with someone who's going to die is very helpful if you don't have the money in your own bank account to pay the bills until you get access to their money.
What Linda said is joint ownership is really convenient when someone's about to die, because they put a joint tenant on the account with them, and that person can help transition from before they're dead to after they're dead in terms of making payments. What we're saying, Linda, is you have to do that very intentionally.
You have to do it intentionally, but please do it if that's important. When my sister died, I was paying all of her bills and paying back her clients until I had access to her money. If we didn't have that money, it would have been extremely complicated.
Yep.
So
It's kind of a case by case basis on how we advise on that, and we've accepted that it's okay to appoint a joint owner on a bank account with you, but it really depends on the circumstances. I mean, because there are unintended consequences of that, right?
Right.
Like if your kid is on your account with you and your kid gets divorced, all of a sudden the $300,000 in that joint account looks a lot like an asset to be divided in divorce, and we don't want that. So,
Or if they're sued.
or if they're sued. Yeah.
Right.
So we proceed with caution on joint bank accounts with someone other than your spouse. Or maybe your spouse. Yes.
The question was whether it's preferable to put beneficiaries as on a bank account, or to put the trust as the beneficiary of a bank account. And the answer is it really depends on your intention with that account. If you want someone to specifically receive that account, then of course put that person. If you would like it to be flowed through the trust, then you can certainly put the trust as the beneficiary of that account. The one thing I would say is that proceed with caution, of course, with retirement accounts and a living trust, because you do not want those flowing through a living trust for tax purposes.
So. Great. So Hannah, let me ask you, I guess I'm talking next, aren't I? I would not take this case, to be very clear. There's no way in heck I would take this case. Lindsay's braver than I. And so I'm tasked with talking about a few things related to the administration of an estate, and specifically the issues that come up with regard to personal property, which there are so many. You guys, like I think I've told some of you, I have been in the middle of family battles about socks. I've been in the middle of an 11-year-old girl represented by her mother, whose ex-husband died, who was fighting with the current wife about the husband's, or whatever, the deceased person's duck calls, right? The 11-year-old didn't care. Let me just tell you that right now. This is emotional stuff, right? We're not fighting about diamonds. We're not fighting about fancy cars. We're fighting about sentimental items that really you don't want to pay lawyers to fight about. So what we always say is, Hannah's going to touch on this a little bit, but talk to your kids, see what they want, write those things down in the little personal property list that we have for you. If you don't have the list, we can get you one, but you can also write it on a Post-it note and slap it on your will or trust, as long as it is signed and dated by you. So personal property is a lot of what we deal with in the administration, and after someone dies, the clearest you can be is to put things on a list. And what we've started to do is just give full authority to the executor or trustee to just deal with it after that. If that doesn't work for you, we can talk about other ways. We can do drafts of personal property. We can regulate it somehow, but that is a very big issue. and in our practice. And I hate billing for it. I'm not going to lie to you. I will do it if we need that kind of support, but it's not our favorite thing to do because no one's happy at the end of that, right? Spending money. I mean, yeah, I won't go into it, but we like to be clear. So if personal property is important to you or certain items are important to a certain person, make sure you get that on the list. Put it with your will or living trust. I actually don't know that we talked about Bill's. Oh, we did. In Bill's scenario, he had Venkman, the dog. Dogs are personal property, so are cats. So are all pets. Personal property, you all know this by now, but it's easier to understand what it is not versus what it is. It is not real estate and financial accounts. You can't give a bank account on that list we gave you. You can't give real estate on the list. You can give stuff. So it's basically everything else, including cryptocurrency. But as we now know, Venkman is an item of personal property that should have been on a list to clarify if the girlfriend living in the house is going to get Venkman or if Scarlett's going to get Venkman, right? I've had people fight about dogs, which makes a lot of sense because dogs are the best. So are cats. But I'm allergic to them, so I don't have one of those. So. But really, people have written checks to siblings so that they can keep the dog, the family dog. So, let's be clear and get a home for Venkman, make sure it's the right home. One of my horror stories is that I had a farm out in Adams County with 26 animals, peacocks, domesticated ducks, horses, dogs. But those are expensive to maintain, right? It was a chore to figure it out, and this gal was not prepared to die, and she should have been. She was not young, so she was taking care of this whole farm by herself. We had, we kind of hodgepodge people to come in and take care of the animals, but it cost the estate a lot of money to figure out how to take care of the animals, make sure they were safe, fed, and then also find a home for them. We were paying people to take the animals, and we will not let an animal go anywhere but to a happy home, so that's something we like to prioritize. The other issue that Bill has, which is a great issue, is that he has a taxable estate, right? I'm going to touch on this really briefly. I think all of you know a little bit about the estate tax. We have one in Washington, where we have an exemption of $3 million. It's now $3,076,000 because of inflation. That exemption went up. If you saw our newsletter last summer, it went up from $2.193 million to $3 million last July. So that's a good thing. The rates also increased. So sweet Bill, who did no updated planning, will have about $1 million of exposure to the estate tax. Depending on, I wish I had the number for you, but let's say it's 20%. That's gonna on the higher end. It wouldn't be that high, but it starts at 10.
10%.
It's called 10. Hannah says it's 10%. She knows the brackets better than I do. So 10% of the million would be paid to the state of Washington. Apparently Bill didn't care because that's what's going to happen, and there's not much he could do about it. But at least he could have addressed it and maybe done some cool things beforehand to save his kids. But that's probably not the first thing I would have told Bill to worry about. So, but it is important to understand he had a taxable estate. We have an estate tax. It's one of the worst in the country, but it is something that we can plan around. So, okay, now Hannah gets to talk about whether she'd take the case.
Man, can you hear me? Okay.
Maybe try this one. It might be better.
Is this one better?
I do think that was
okay. Well, there it is. I don't know if I could take this case, but man, part of me would really want to because this is such a sad story. This is the story of someone who just did not update their documents at all and absolutely should. We consider an estate plan here at this firm a gift to your family, right? That's the whole point, is to make things easier when you've died for your family and to celebrate the relationships that you've had. And this is just a total mess. Yep. I mean, there's a number of things that Bill could have done and should have done. I mean, the first of which, right, is this live-in girlfriend who may or may not have what Washington calls a CIR, or it's basically like common law marriage, right? When you live with someone, you can create community property without even intending to do so. And so failure to address that and to even mention her in his estate planning documents, I mean, that creates a whole mess for his family that Scarlett particularly has to deal with now. We also have a minor child. That's a huge, huge, huge deal, right? When we're dealing with a minor who is inheriting money, who is a beneficiary, well, first of all, George wasn't even mentioned, right, in the estate plan, which was done, several years ago. When a child is not mentioned, they are by law entitled to an equal share of all the other children, okay? So by operation of law, George will inherit, but it's just gonna be really, really messy for Scarlett to figure out, okay? Also, we have no way to route the money to George. George is under the age of 18. He can't inherit legally. The money has to go to his mom. And his mom does not get along with the family. Mom is the legal representative for George. She's gonna take over the guardianship, by the way, side note. So Bill won't have that anymore, of course, because he's gone, but that means she's making all decisions for him. So every time we have to bring George into any decision making, which will be a lot because we gotta go through probate as well as the living trust administration, we have to go through mom to get there. And so by failing to update his documents and include his children and include, his new girlfriend, he's creating a mess not only for Scarlett, also for his new girlfriend, who he presumably loves, right? And for George, one of his minor child. And so it really is, this failure to plan it's really sad to me, right? Because it's created this whole mess that didn't need to be there. And that really could have been addressed a lot earlier and in a manner that makes sense for his family. Also, we've talked a lot about the living trust trustee appointment being different than the executor appointment. Obviously, that's going to be an issue and should have been something that should have been addressed. But something that I always am thinking about in the back of my mind, and I always, want my clients to be thinking about, is the dynamic between the people in your family, right? Do they get along? Do we want to put them in positions where they have to make decisions about each other? Or do we want to maybe take that out of the family? Is there a natural leader in the family, someone who's kind of a doer, and it would make sense? It wouldn't be a strain on any family relationships. It's like I said, it's a gift to your family to really thoughtfully plan who should be in what role, because selecting the right people is a really, really big deal. Having a estranged felon as the executor for assets that are outside of trust in California, not ideal, right? Especially when he doesn't get along with the trustee. So that's some things that come to my mind just when I hear this fact pattern, and I think about whether I could take this case, because this is we could, we have the expertise to handle this kind of stuff, but it just becomes a huge mess. And like Lindsay said, a lot of lawyers will turn this down just because it's such a mess. And so really the updating of the documents, and on maybe a less extreme scale, right? But for you guys day to day, when major stuff happens in your life, it's important to update your documents. It's the whole point of the Bridge Club, right? The people I appointed as guardian for my minor child are no longer together, right? So it might make sense to update that kind of thing. Oh, I have this new property in California. It's awesome. We love going there, but we got to put it in the name of the trust so our kids don't have to deal with that, right?
Timeshares.
Timeshares are a big deal too. You always want to make sure that those are titled correctly, so we can avoid probate, right? And it kind of depends on timeshare to timeshare. So see us if you have questions about your timeshares. But this all just comes back to the legacy that you're leaving for your family, right? That's the whole point of the estate plan. I always like to talk about communication too. I do not believe that you need to tell your family, the nuts and bolts of what is in your estate plan, right? But maybe you certainly need to tell your executor or your trustee where your documents are. That's baseline to me. But, talking to your financial power of attorney or your healthcare power of attorney about, this is what I consider quality of life. These are the kind of decisions that I would like to be made on my behalf if I'm ever diagnosed with dementia and I can't make decisions for myself, or if I'm in a situation where I have no brain function, those kinds of things. And I recognize that it's not like the most cheery conversation to have, but it is important, and it is something you could also write down, right? If it's something that you feel that you would want to leave in like a letter for your children or for your executor. It's always wonderful when we see letters from deceased family members that the children are opening, and it can really mean a lot. So yes, Linda?
When you write down your intentions for your health care, doctors will pay better attention to it than if your healthcare advocate is saying it. Doctors are very reluctant to listen to an advocate. Trust me.
Can you repeat that?
Yes, I will repeat it. Linda is suggesting that you write down your wishes for your healthcare decisions as opposed to just telling someone. And I will say I totally agree with that, because even if your healthcare power of attorney thinks that they know what you would have wanted, if you're in that situation, it's a whole heck of a lot easier to make those decisions if you have something in writing, right? We sometimes call the healthcare directive the guilt mitigation document, right? Because that's kind of the point, right? You're taking that decision, that huge decision, away from your healthcare power of attorney. So.
And doctors respect it more. That's
Yes.
a big point. I've had big fights with doctors until I show up with, here are all the conversations we had in writing.
Yes, Linda is also saying that doctors respect the decisions more when they're in writing. That's right. So, yeah, I think in conclusion, it'd be hard to take this case given, how busy our firm is, but I would feel really bad turning it down.
Okay, now I feel bad that I said I would not take it, because we could really help this family and maybe get them to be all friends again. Would be our goal. We'd probably fail. So I would love to try. So we're not, trying to shy away from a challenge, but there's a lot of things in this that would just make my head spin. And it made, as we were writing it, my head was spinning.
We have a question.
Question.
Yes. When it comes to location of important documents, I would love to give them to our executive, but she will forget where they are.
Question.
Yeah.
Did everyone hear that?
It's not a question yet.
Oh, okay. Oh, I love
The
this.
question is,
Oh no, keep going.
go ahead.
No, you keep going. I'll finish and summarize.
Can we leave that kind of information about where the important documents are with you? Is that an option?
Yes, you can leave that information with us.
Repeat the question.
Oh yeah, did we not hear it? Okay, I thought you projected pretty well. The question is, will our firm keep the information about where original documents are located?
Yes.
And something that I think we all do is when we talk to you during the signing, we make a note of where you intend to leave your original documents, so that's in our file. But if we don't have that conversation and it is something you want to do intentionally, we are happy to hold on to that information. But again, to Lindsay's point, someone's got to know to call us.
But then that's just one thing that your executor has to know. Narrows law group.
That's it. And I think, my job now is to give you some takeaways. Pens. The takeaway starts with what Lindsay said first. What Scarlett did well was call the lawyer. Call the lawyer. That's part of the Bridge Club thing. And you guys are already in it. I'm not selling it. You already know what you get. It's a free consultation. And frankly, we wouldn't charge them anyway if they called, but at least they know that they're not going to get a bill for 0.7 because we talked to them about their mom dying. We're not going to do that. But we want them to know that they're not going to do that, and we want them to feel very comfortable calling us to talk through some of the issues. We have an awesome team here, so we're in meetings a lot, but anyone on our team can help you out, and at least document that you called. Yeah.
Thank you, Annie. And you answered my question, but I need to add another level of detail. I wasn't really talking about the original documents, but the other things like passwords and what to do with the dog and those other details, can we also share that with you so that they have those things?
Can you share
The-
anything with us?
Yeah.
Is the question.
Yeah.
Absolutely. We have a secure system, and I would love if you would. I've gotten personal property lists. We get all kinds of information that we can store securely.
Perfect.
Yes.
This is me just being a stickler. If your executor calls and says so-and-so has passed, I need a copy of, their files, I am going to ask for a death certificate. Because on one occasion, do you remember when I first started working there, a son called for his mother's estate plan because she had passed away. And I thought, well, she's married, so let me call her husband, who is actually the executor.
Right.
And imagine my shock when she answered the phone. And I said, oh, well. You're alive! Do I have some news for you? And I just didn't know what to say. I said, well,
How's it going?
just checking in. I said, I was informed you had passed. And she knew exactly which child called me.
Oh, God.
Because he wanted to know about the estate plan. So just know that if they are going to call us, we are going to ask for a death certificate, which is also my number one rule of we can't do much of anything until we have a death certificate.
Yeah, we learn those things the hard way. And I think it's important to know we are trying to open this conversation and make sure that everyone's really comfortable with us. We are lawyers, right? We're going to do our job and make sure that someone has died. Or, that someone's incapacitated, right? We're not giving stuff to your kids. I think we talked to each and every one of you about our ethical obligations, which are very intense, right? We have really high ethical fiduciary responsibilities to each of you, and we don't take those lightly. So we will... They might not love it, but we are going to confirm that mom is not here anymore before we give them all the information. So, yeah, I think that's a great question. And, we haven't opened the door to that much, but every time someone asks us if we'll hold it, we absolutely will. Yeah. Caveat, one more. Lawyer stuff. I don't want passwords. I don't really need social security numbers. That's the limit. So passwords aren't... Would you guys agree?
I don't take passwords.
We don't take passwords. Sorry. No, so that gives us a lot of access that ethically we shouldn't have. Yeah. So sorry, I feel like I burst your bubble there, but I appreciate the trust. But something like Bitwarden online is a great website. That's what we use. Yeah, Indy, she knows. LastPass is another one. I don't like it as well. But yeah, okay, good. Knows, okay, yeah. Oh, it's compromised. Okay.
We gotta.
How about Bitwarden?
That was my question.
Oh, it was it?
Recommend a password company.
Yes. Do we recommend a password company? I recommend Bitwarden. All right. Thumbs up.
Not sponsored.
Yeah.
You can also leave on the refrigerator along with whatever for EMT folks. You could leave something there with passwords.
You sure could. I think it depends on the trust level with your family and the EMTs. Don't you love a neon green DNR on your fridge? Isn't that fun? Okay, so I think back to the point, which was call the lawyers. We're here to help. I would also extend that to not just death, but incapacity. We're your team. But this isn't on my list of takeaways, but I do think that if there is a diagnosis of dementia or Alzheimer's or Parkinson's that would affect your capacity going forward, maybe it isn't now, we got to talk. We need to have some serious conversations about what that means going forward. Just get ready for what's coming, okay? Because that changes a lot in the estate planning world. Okay, so I'm trying to break it down to helpful things that we believe you should be doing now / considering for the benefit of your executor or your trustee. Call the lawyer. That's it. So again, communicating to someone important that will help out to that they need to call us or the executor needs to be in contact with us, however you want to create that scavenger hunt, that Hansel and Gretel path. For me, I have a password hidden in my sock drawer that gets into the safe, that gets into all of the exciting stuff in there. So that's what works for my family. And figure that out for yours. I guess we can help you talk through it, but you got to make that decision. To Caroline's point, review your estate planning annually and your asset list annually. It doesn't have to be with us, but it should be done by you. So tax time, we all love tax time. Just pull out another file, look at your stuff, make sure that the summary looks consistent with what you still want and that your assets, you can include approximate values, but what I'm looking at is making sure beneficiary designations and titling on accounts, financial assets and real estate are correct and updated. Communicate to your people. We talked about this, where your documents are. Also communicate your professional advisors. If you have a financial advisor, if you have a CPA, and us, your lawyers, we call it the trifecta, right? We'll get it all done for you. If you have those people, make sure that your family knows who they are and who we should be contacting, or who they should be contacting. Pre-arrangements for disposition. Lindsay's right. This is the best thing that you can do for your kids or your family. It means they don't have huge costs right at the outset that they have to cover personally. If you've already paid for it, you've made those decisions, they're not getting the hard sell at the memorial home, so they can zip, zip, zip through it, get it done, and they're not out of pocket. They'll get reimbursed, but it is expensive. Yeah.
I have a question about that. So if you prepay your funeral or cremation, does that go in your living trust? Do you guys need those documents, or is that an asset or personal property?
Yeah. So her question was, if you do prepay, does that go into any of your estate planning documents or your living trust? So we don't assign it to your living trust, but in your disposition documents, I will say, I have made prepaid plans with so-and-so, and here's my account number. So that way it's also accessible. Yeah.
Or at minimum, put the paperwork in the file with your doc. They'll figure it out, right? Yeah. But no, it doesn't have to be owned by your living trust. It's kind of a slick asset. Oh, everyone's favorite. Ask your kids if they want stuff. Mom, do you know what I want versus what Hannah wants? I'll tell you. Okay, so we need to have some important family conversations. I don't want to duke it out with Hannah. So, but do ask. They might do that. And they're like, nothing. No one wants your china. Except if they do. You have good china. But you go to Goodwill and it's all china. But maybe they do want it. I have an old, some of you have seen it in our conference room in Tacoma. There's this weird little frog, garden frog. It was in my Nana's purple bathroom for 20 years out in Michigan, and I wanted it. Now I got it. So it's in the conference room. But I told her I had wanted it, so she made sure I got it. That's not sweet. In my family, between us, Hannah. Hannah is the favorite daughter, for clarification. Yes, who is the favorite? I love it. The hard questions.
The baby. That's mom.
Yeah. Okay, and so I said this earlier. Give us a call. I think a timeline is appropriate. Lindsay's saying when you get the death certificate that we can't do much until then, but please feel free to call us anytime. I will say maybe wait a day. Just a day. I mean, it's highly, highly emotional, and there's not much we can help you with, within a week. We always say, feel free to call, but what we'll tell you, I'm telling you right now, go take care of your family. This stuff can wait. This will all be here waiting for you. So we say about a month, we need to start doing stuff. You might have a need to do it beforehand, and that's fine, but we can't do much practically without the death certificate, and we shouldn't do too much before you're settled a little bit. There's a lot of details to take care of that aren't legal, so we always want to make sure you're taking care of yourself and your family. But sometimes this is what you like. For us, we love this stuff, so it makes us happy to get it done. But I would say at least wait until after the memorial if you're going to have one in short order. And that, you guys, that's kind of the takeaways. Yeah, now we're open to questions. It's question time, Mom. Yeah.
No, I'm really curious about Bill. The will. If you had done the original will for Bill, wouldn't you be obligated to help Scarlett? I'm assuming this is a new will, someone else.
Yeah, the question is, wouldn't our firm be obligated to represent Scarlett if we had drafted the POS will for Bill? No. Ethically, no. Hard line. But if Bill were our client, I would be out of business.
No,
but
Bill wouldn't be our client.
If Bill had been, if we had prepared the documents for Bill, we would absolutely take the case.
So
Bottom line.
Do you often get a lot of people with other wills that other lawyers did and they come to you? I didn't know that.
Do we get wills to probate drafted by other lawyers? Oh yeah, yeah. What's your oldest will? I got one from 1962 once.
Oh, no, I think probably the 70s.
Yes.
Yeah.
Yeah.
With the seal.
Silly, I'm talking about. Any other questions? Yes. Want to talk about that?
The question was, can vehicles pass without probate? And the answer is yes. I am so pleased to say yes to that question. They are annoying to retitle, and you can actually lose some benefits that you have for like disability if you put them in the name of a living trust. That being said, if you buy your car in the name of the trust, that's just fine. There's no problem with that. But you don't have to retitle the cars that you currently own.
And to add on that, if you don't have a living trust, you only have a will, but you were really great, all of your assets had a direct beneficiary, and all they have to deal with is a car, we're not opening probate for your car. You are going to the Department of Licensing, filling out some paperwork, and getting it to the right person.
I can answer this. So the question was, if there are assets that are in one spouse's name, can they go in the name of the trust? And there's a couple different layers to this. The first is it depends on what the asset is. Retirement accounts, for example, have to just be owned by one person, right? You can't own them jointly. So those do not go in the name of the living trust, mostly for tax purposes. Because if we put the living trust as the owner of a retirement account, the account actually is liquidated, and instead, you pay the taxes and the penalties at that time. So instead, on those accounts, we have beneficiaries on them. But let's say, another layer to this, right, might be separate property, right? If we've inherited separate property, we want to keep it separate. Typically with a living trust, the assets are joint if they are in the name of the living trust, unless they've been specifically called out in that trust, which we can certainly do for you. But before you put a piece of separate property in the name of your living trust, talk to your lawyer, because you can make it joint by putting it in the trust without calling it out specifically. You can also add the trust as the beneficiary of those kinds of accounts, but I'm kind of getting in the weeds now, so is that? Yes, so the question is, if the assets are just in one spouse's name, but they have beneficiaries on them, do they avoid probate even though they're out of the trust? The answer is yes. Beneficiary designations avoid the probate process as well. Oh gosh. So the sticky situation that was just described is we have RMDs coming from an individual retirement account. The bank will not cash the check in a trust account that's made out to an individual. First of all, banks can be the bane of our existence up here because that's not the case for a lot of banks. So I'm sorry to hear that. The workaround that I would suggest is you keep it in your name, the bank account, and then you add the living trust as the beneficiary of that account.
Yep.
Yeah.
Also, what bank?
Yeah, what bank is that?
We'll talk later.
Yeah. You can talk to me after this. No.
Yeah.
An uncooperative bank.
Yeah.
I want to know.
Yeah.
I know. Give us
Maybe when the tape stops rolling.
Oh, yeah. Yeah, fair. Any other questions?
Anything else?
New probate rules are coming out, you said,
Yes.
for Washington?
For
Are you
Washington
going
State.
to do like a little website list of how they're changing, or?
Can you repeat it?
So the question is, she caught on to the fact that I said that new probate laws are happening. I think they're June 11th that they are being enacted, and whether we're going to update the website. That is an ongoing conversation we have talked about. Of course, I think in the newsletter, right, is where we like to send out a lot of our updates. And maybe now we'll do another Bridge Club event on it. I will admit that they are sitting on my desk and I have started reading them, but I am not done with them. And I do think this is really, it's actually astonishing how quickly they've gotten these rules out, because it was only probably this fall that the Attorney General said that the changes were coming. And I have a feeling these aren't the end, because I know there are things that are still in talks, but we will definitely get updates to our clients once we digest and streamline and get rid of the legalese for you guys and tell you how it will practically affect probate here in Washington State.
I think the good news is it's not as much of an effect right now as we feared, that the rules have been enacted to combat some fraud that's been happening in the probate world, and specifically with regard to one guy who would open probates for people that he didn't know and then send fake notices. I'm looking at Jen because she's more familiar with the cases, but he'd send out fake notices that he'd file an affidavit with the court saying that he notified the heirs of the estate, but he didn't, and then he would flip houses and pay himself as a contractor, and then also, I mean, it was just exorbitant fees, so this guy was making out like a bandit, and I think he is out of the country now.
He's on the run.
Yeah, he's on the run, so all these laws came because of him, and it's kind of fascinating, but it doesn't, the application to your probates is very small. In fact, I would say almost non-existent. There are a couple things on the administrative end that we'll have to deal with, but it's for the greater good. One bad guy.
Not like going forward the way California is, which is a percentage of the state thing.
No, my understanding is not that. It's more tightening up on who can serve as a personal representative, types of notices that are going out. And I mean, one of the immediate things I noticed is I had to last month, a couple months ago, attend a hearing for a copy. We had to admit a copy of the will, which normally we get the witnesses to sign off on these declarations and they'll admit it without us even having to go to the courthouse. And this time they did not. They required a hearing, as they are allowed to do. So that's actually working under current probate law, but the judges are using their discretion to say, well, we're actually going to be a little bit tighter and require you to come and have a hearing in front of us, which took more time to open the probate. Cost more money, of course, but it's understandable. They just want us in front of them, explaining ourselves to them. I
think it's the tip of the iceberg, actually, with the probate laws. I don't think they have much effect now, but we're keeping a close eye on them. But the newsletter will have a whole breakdown of the new law.
Yeah. But also, your original will is very important. Please let your executor know what that is, because if you have a living trust, you'll have noticed that copies are as good as an original when it comes to a trust. When it comes to a will, yes, I can get it admitted to probate. It is going to take longer, and now it's taking it a hearing to do so, which it didn't before. So. Yes.
That scenario you said where you had to have a hearing for probate.
Yes.
Is that just case by case, or is that?
That is case by case. So he's asking when I had to go to a hearing to open a probate, is that case by case, or is it all across the board? That is case by case. If I have an original will and we send it in to the court and open up probate, we can our lovely Jennifer over here handles it all online. It is great. We wait a couple of days once all the documents are in and once they've authenticated the will, and then we order letters to come in, and no one has stepped foot in a courtroom. But right now,
how long is probate in the state of Washington?
Oh, this is my favorite question. Because it depends.
Repeat the question.
Repeat the question. How long is probate in Washington State? So my answer is always, it's a minimum of 4 months, because it is my practice. It is not the law that you have to do this, but it is my practice, our practice, that we are publishing notice to creditors that I talked about earlier, and that runs a 4-month creditor claim period. And then I get to tell you, the rest of it depends on how long it takes to wrap up the estate. How long does it take to settle any arguments over personal property, sell the house, and then the biggie, do the taxes. So if you have someone who's passed away in the beginning of the year, I tell you, we're waiting until next, end of January to get the tax documents in order to finish up all of the tasks. Doesn't mean we can't distribute and get a big chunk of everything done, but we're not officially closing until taxes are done. And so sometimes when I say if someone's passed away in December, I go, you're in luck. We could be done by May.
You guys, I see one more question, but we did promise 7:30, and I realize it's past. So we actually, here, I'm going to pass it over to Kristen to close us up here, but we'll be here for a few more minutes if you want to come say hi.
Thank you again so much for coming. It's so great to see all of your faces, and I hope you enjoyed our very first seminar. We do have a heart out, so we have just a couple more minutes to mingle and maybe introduce yourself to someone, and then we'll be closing the doors right at 8 o'clock. So thanks again, you guys. Have a great evening.